Are you a seller of residential real estate in Florida? If so, your listing agent has probably presented you with a residential real estate seller's disclosure form and have requested that you fill it out. You might be wondering, am I required to fill out this form? Well, whether or not you're required to fill it out depends on your particular circumstances. If the listing contract that you signed with your listing brokerage required you to fill it out, then you might have a contractual obligation to do so. However, generally, there's no statute or law that requires you to fill out this form to give it to the buyer. However, just because there might not be a law or statute that requires you to fill it out to give it to the buyer, that does not mean that you do not have certain legal obligations to provide information to buyers of residential property under certain circumstances. In this video, I will discuss what are the requirements to disclose information to residential buyers under certain circumstances. But before that, please check out this brief disclaimer video. This is Ryan Ramsrand, an attorney in Palm Beach County, Florida. Welcome to my channel. The purpose of this channel is to provide general information about the Florida real estate market. It is not designed to provide specific information tailored to any individual real estate transaction. If you need this type of information, please consult with your own attorney, real estate agent, property insurance agent, settlement agent, or any other service provider that you choose to work with for your particular situation. The viewing of content on this channel does not create an attorney-client relationship between the viewer and the law office of Ryan A. Ramsrand, PA. Although every effort is made to provide accurate content on this channel, because the Florida real estate market is so dynamic, there's no guarantee that the information will be accurate when you view it or will remain accurate in the future. The law office of Ryan A. Ramsrand is a title agent with Attorneys Title Fund Services, LLC, and issues title insurance policies underwritten by Old Republic National Title Insurance Company. The firm also represents companies and individuals in the acquisition, sale, and development of commercial property, such as hotels, warehouses, and industrial property. If you believe my firm might be a good fit to represent you in real estate matters, please see the firm contact information under Details in the About tab of this channel. In addition to real estate matters, my firm also accepts personal injury cases, as well as cases related to the violation of individual civil rights. Please note that these cases will be referred to another law firm. However, under no circumstances will the client be responsible for paying fees or costs in addition to what they would be paying if they only hired one law firm. Again, thanks for viewing content on this channel, and let's get back to the content we were looking at before. Thank you. Welcome back. So the standard in Florida is that sellers have an obligation to disclose facts about a property that are not readily observable by the buyer and that can have a material impact on the value of the property and is unknown by the buyer. This is essentially a paraphrasing of the rule as established by the Florida Supreme Court case of Johnson versus Davis. Now, when the listing agent presents the seller with a residential disclosure form to fill out, this form is essentially a tool to try to encourage the seller to comply with the rule as established by Johnson versus Davis. The form has places on it where both the buyer and seller must initial. And on the signature page of the form, the buyer is acknowledging where the buyer signs that it has received, read, and understood the contents of the form. This way, if the buyer comes back at some later point and makes an allegation that the seller did not disclose information that had a material impact on the value of the property, the seller may be able to use this form provided it was properly filled out and the seller was forthcoming in its disclosures as some measure of protection against an allegation against the seller. Please note that I want to make it clear that the standard under Johnson versus Davis applies to residential real property. So in Southeast Florida, where I practice, most residential real estate transactions are done under FAR/BAR as is contract. So some sellers might be wondering, if I'm selling my residential property as is, am I required to comply with the standard as established by Johnson versus Davis? And the answer is yes. There is Florida case law that confirms that sellers of residential property that are selling their property as is must still comply with the requirements of Johnson versus Davis if the circumstances are applicable. It should be noted, though, that the Johnson versus Davis standard does not apply to commercial transactions. If this information was of some use to you, please like and consider subscribing. Until next time, be safe out there.